जनाब अली, आज हमने एक रेट सेपरेट सबमिट किया है बिफोर द ऑनरेबल कोर्ट। उसमें हमने ये इस्तदा की है कि जो 26 अमेंडमेंट के तहत जो अहकाम जारी हुए हैं उसके तहत जूनियर जजेस जो है वो एलिवेट हो गए और सीनियर रह चुके हैं, और जूनियर जो है वो अभी स्टिल मतलब उस सहूलत से महरूम हो गए हैं। इनके ख़िलाफ़ हमने इसी हाई कोर्ट में एक रेट फाइल किया हुआ है और ये रिक्वेस्ट की है कि जनाब अली इस अमेंडमेंट के तहत जो सीनियरिटी लिस्ट है उसके मुताबिक एडजस्टमेंट होना चाहिए और उसकी वायलेशन जो है वो अनलॉफुल है और अगेंस्ट द कॉन्स्टिट्यूशन है। ये किया है और इस्तदा की है कि जनाब अली इस सीनियरिटी को मतलब जी जो सीनियरिटी लिस्ट इशू हो गई है अनलॉफुल, उसको सस्पेंड किया जाए और फर्दर जो है आप सीनियरिटी के तहत हमारे ऑनरेबल अपॉइंटमेंट करें और इन फ्यूचर इस पर अमल भी करें। यही हमारी इस्तदा है।
सर ये तो गैर कानूनी तो हम इसको नहीं कह सकते जब तक 26वीं आईनी तरमीम जो है वो फील्ड में है, तो क्या कहेंगे इस पर?
Actually, the answer of your question is that already we have challenged the 26th amendment in the shape of writ petition number 5849, which is sub judice before the Honorable Peshawar High Court, and see it has been held in PLD 1958 page number 401. This is the judgment of the Honorable Supreme Court of Pakistan, wherein it has been held that when the basic or foundation of a building is weak, then the entire edifice structure thereupon will be collapsed automatically. So at first we have challenged the very amendment which has been passed in a very haste in a very 2-3 hours and night by night.
Sure.
So once the very amendment is unconstitutional and is against the fundamental rights, and see already I had submitted that see article 175 sub-article 2 is still in field, which says that judiciary must be independent within a period of 14 years after the commencement day of the constitution, which is still intact and that has not been amended. So this amendment by itself is in contradiction with article 175 sub-article 3 of the constitution. Similarly, if we look to article 2A of the constitution, which is the substantive part of the constitution, that is called objective resolution. So therein also it has been held that this constitution is the voice of the public, and wherein the independence of the judiciary shall be fully secured. So that article 2A is also still intact in the constitution. So we do not understand that how this contradiction will be maintained and harmoniously interpreted by the honorable courts. Similarly, if we look to entry number 55 of schedule 4 of the constitution, which says that no power can be taken from the Supreme Court, although it can be exceeded, furthermore power can be given to them. So see, once the parliament had no power to pass such an amendment, so that power or that exercise of power is quorum non judice, void ab initio or non est. So see, once the very base of the 26th amendment is illegal or unconstitutional against the independence of the judiciary, against the fundamental rights, so later on subsequently whatever is made there under, so that will be automatically quorum non judice, void ab initio and illegal and against the fundamental rights. And article 8 by itself is saying that see, no law will be made which is against the fundamental rights. So I have my concise statement that the appointment of the junior judges as the acting Chief Justice of Peshawar High Court and Islamabad High Court, and dropping the senior most judges without any reason and rhyme is quite unconstitutional, irrational, unreasonable, against the transparency, against the fair play, and against the voice of the people of the country, because they are the masters of the country as is held by the Honorable Supreme Court of Pakistan in PLD 2012 Supreme Court page 466 and PLD 2015 Supreme Court page 401. So how the servant will exceed their power which has not been conferred upon them by their masters, by the people of Pakistan. So the honorable people of Pakistan have constituted this respectable constitution for the country after a long debate and after a long fight with the executive, and thereafter the independence of the judiciary has been fully secured, which shall be, and such a power cannot be taken from the honorable courts. And similarly, in Al-Jihad Trust case, PLD 1996 Supreme Court, page 3 to 4, it has categorically been stated and held by the Honorable Supreme Court of Pakistan that senior have the right to be appointed as the Chief Justices. So this appointment, and as well as the 26th Amendment, is in contradiction with the full bench order of the Honorable Supreme Court of Pakistan.